mayor and council are inclined to seek collection of the unpaid utility fees for those 4 customers that benefited from the decision made back in May 2009. It's our opinion that the law in Maryland would support that collection. The one thing that we recommend, and you have a draft ordinance to this effect, that if you proceed that way, you may be inclined to give those particular customers time to pay those amounts, because in some cases, I don't know what the totals are, but so there's 4 accounts. I'll just read the totals for each account that would be due if you decided to collect. $1,410.50, $1,105, $4,309.50, and $9,120. So you have 4 counts. Those were the unpaid amounts. If you decided to collect, but you also wanted to give these customers more time than normal to pay these amounts back, we've drafted an ordinance that would give the utilities board that flexibility under certain circumstances to allow a payment plan different than normally water and sewer charges are due. Now, if you did that, so if you go to collect, you allow a payment plan because some of these amounts are somewhat high, so long as those customers stay on track. Okay, but if they don't stay on track with that plan, it becomes just like any delinquent water and sewer charge. That's the way the ordinance is drafted.
Don't we have to have that ordinance in place before any decision is made?
Well, the decision to collect can be made in and of itself. I mean, that those amounts are due and owing. Then you can move forward with the ordinance, and that'll take effect in 20 days. So I think by the time your staff's ready to send out the bills or whatever, you have time to do that. I mean, you could certainly wait, and if you introduce the ordinance but you haven't made that decision, you could do that. But I think the threshold question is collecting or not.
And if we chose not to collect this, the odds are in court that we would lose.
Well, I don't want to handicap it because I don't know what the nature of the suit might be, but I think there is more law in favor of collecting than there is not. But the not part of that would be dependent on some other group challenging the town not collecting. And without knowing what that looks like and what the complaint would actually be, I can't really handicap it, but as I said earlier, when we looked at this and researched it, we think there's more on the side of collecting to avoid what is referred to in the law as rate discrimination.
Chip, back in 2009, when this part of this took place, was that all discussed in the public in the very beginning?
I don't know.
Or was that just an executive session?
I don't know.
That was an open session.
Yeah, the first part was in open, and then there was an executive session.
I'm not sure about the executive session. The discussion that relates to this was in open session.
Okay.
And listening to that tape in 2009, and on behalf, of these 4 account holders that you elucidated the amounts, what can you disseminate between the town's role and their role as to whose responsibility it is to follow through on that?
Can I request that the mayor rescind himself, not participate in this discussion, as he is an officer of one of the companies?
I think it's a fair question for these account holders, because again, I mean,
That he
in
should
all,
participate in
Thank
any
you.
way because of his monetary interest.
thank you. Again, Chip, can you, again, just disseminate between what the town's role is and any one of the 4 customers?
I think that comment's worth heeding, but I don't quite understand your question.
The question being is, at that 2009 meeting, which was an open meeting, there were customers that were afforded a rate reduction. And again, my question is, there was a time frame that was put in place by the town. So I guess the question is, whose responsibility is that to follow through on, after that time frame was put in place?
I don't know.
In 2009, didn't you abstain from that whole conversation?
I did. I abstained from it because,
You
again,
should eat the word of what she said.
well, I'm asking the very question, though. I think it's important that
It should
to
be
know
your-
the difference between the town and
It should be
Oldville.
your father or somebody else asked that question for you, since you abstained from that.
Well, I think for the other three accounts, even outside of the business that I'm associated with, that there was some position taken on that.
I will say this, under the law, if there was an act that was made of questionable authority, you can't rely on that act. So I don't know, it doesn't really matter right now about any kind of assurances made back then. I think we're operating under the premise that that decision in May 2009 was without authority. And that's why it's been rescinded. And then the open question is the town compelled or in any way obligated to seek collection of unpaid or previously discounted fees?
I think the only issue that I may have with it back in 2009 was these 4 accounts, one of them requested to have a reduction, but the others were automatically incorporated into that. Is that correct? Because they were out,
That's because they were, they're the only 4 accounts the town has
That are like
that is
that.
part of the same billing code. So if you did it for one,
You'd have to do it.
you did it for all
Right.
4 of them.
Right.
Yeah.
But is that fair, if they did not ask to be in that, for them to have to pay back something they didn't ask to be a part of?
I would answer it this way, it's fair to all the ratepayers. And it's as fair as possible if you give them time to bring their accounts full.
Okay, so at this point, it's up to the council to make a decision on how to proceed.
I would like to renew my conflict of interest on this issue. The mayor is running a meeting in which he has a direct financial interest.
Thank you for your comment. At this point, I'm asking for the council to make a
I think the
decision.
mayor should leave the room during this whole conversation.
I'm going to go ahead and run this meeting
Total
forward,
conflict.
but
But
it's
hey,
going to be
hey,
up to
wait.
the board as to make a
Right,
decision.
and I'll say this,
No.
you folks have to respect the ways this meeting's run. If issues of conflicts of interest are self-policing, okay? They all are very familiar with the rules upon which they're supposed to conduct themselves. It doesn't help for you all to do that from this part, okay? I think everybody knows this issue and who's involved and whatever, but it's a self-policing thing, so it's been noted. I think that's where I want to be left.
So again, moving forward with the council's decision, council's action on how to move forward.
I make a motion, we bill these 4 accounts for back fees.
Okay, we have a motion to bill the 4 accounts for the back fees. Do we have a second?
Second.
All right, we have a motion and a second. Any further discussion? All in favor?
Aye.
Anybody opposed? Okay, 3-1 is the vote count to go ahead and move forward to collect the monies from these past due accounts.
And what about you?
I'm abstaining.
Wanted to make sure it was in the record.
Chip, I got a question. Can we go ahead and, for the payment of the payment plans, because just spread it out. Who makes that judgment and what?
Well, what I would recommend then is the next, at the appropriate time in your meeting, to consider the ordinance that's been drafted and get that introduced. And what that does, that will empower the utilities board to decide what kind of plan they might offer.
Is it up to us to see
Yeah,
what we
yeah,
think, and what
you-
what we figure is fair to,
Correct, correct, right.
at that time?
If you want to give them 2 quarters to pay this, if you want to give them 4 quarters to pay it, that's going to be up to the utilities board once you adopt that ordinance that gives you that flexibility.
Okay.